Welcome to All About Bankruptcy.
Welcome back to your legal path to relief with Oklahoma attorney Luke Homen. Luke is the founder of ConvenientBankruptcy.com, where he helps people erase debt, rebuild their lives with a process that's empowering, practical, and judgment-free. I'm Sophia Morales, and today's episode is Can Bankruptcy Really Wipe Out Student Loans and Taxes? Here's what you need to know. Welcome back, Luke. I'm so happy to have you with me this morning.
Thanks. It's good to be back.
What has changed recently that makes discharging student loans more realistic?
So this is interesting and amazing and complicated.
Of course, the government's involved.
Yes. And this is less legal than it is government and politics, honestly. The law really hasn't changed. Congress started making student loans non-dischargeable in like the 70s. Back then, you had to wait 5 years to discharge your tax debts. Then it got to be 10 years. Then in 2005, now you can discharge private debts. And there's a case law called Brunner from a long, long time ago, like the 70s. And that hasn't changed either. So what hasn't changed is actually the law. What's changed is the enforcement of the law. Okay. So another way to think of this is marijuana is illegal in our country. It is still illegal in the United States. It's illegal under the federal government. If you are running a marijuana shop, it's illegal. However, as states like Oklahoma and others have decriminalized marijuana in their own states, the federal government has just chosen not to enforce those laws anymore.
Yeah.
Running a marijuana company, it's still illegal, but they're not enforcing those laws. So that's one of the roles of government, is to choose what laws we're enforcing and to what degree and how crazy we're going to get in terms of trying to enforce these things. Yeah. So historically, the pushback on enforcing student loan debt has been just catastrophic. It's been intense. You try and discharge a student loan debt, and the resistance that you're going to get historically has been huge. It's been, we're going to take every single one of these to trial. You're probably going to lose, but even if you don't, we're going to run you into the ground along the way.
Yeah. And you will spend more fighting than you will spend paying it off.
And that's really the biggest problem, which is the people who stand to benefit the most from student loan relief, the people who need the student loan relief, who are the best candidates for it, they can't pay me $20,000 to go to trial, right?
Yeah.
It's just not going to happen. So what's changed is the enforcement. So diving back into the politics side, here's what happened. Sometime during the first Trump administration, Trump instructed the Secretary of Education, Betsy DeVos, I think that's how you pronounce her name. DeVos. He instructed Secretary DeVos, we have a problem with student loans, and I want you to go study it. And I want you to figure out, should bankruptcy be able to discharge student loans? And as things go in government, they started studying it and nothing happened. Okay. Yeah. So then we changed presidents and we jumped into the Biden presidency, and the Biden presidency picked up the study. They picked up the torch and they said, okay, let's keep going with this and pursue it. And so what was really helpful is they issued some really objective guidance. They issued what we call an attestation. An attestation is something like 40 pages of paperwork, right? In bankruptcy, we're all about paperwork. We've got our 70-page bankruptcy petition, our tax returns, our bank statements. Well, now we have more paperwork, but that's really helpful. And the reason why it's so helpful is we can work through these government forms and we can try and see by the numbers objectively, are you a good candidate in the government's eyes for who should be able to discharge student loan debt? Because before, the idea was, we've got this court case from the 1970s and we'll take it to trial and hope it's a good day, right? Yeah. And that's terrible. It's terrible guidance when you're trying to advise somebody who's broke whether they should pursue this. Exactly. But now that we can use numbers, I joke all the time that bankruptcy is lawyering with numbers. Like we use It doesn't, like, we're not doing calculus. We're just using numbers. We're saying, okay, here's what you should be able to afford. Here's the amount of money in your pocket. And we use the numbers to tell the story. So again, with the student loans, we are looking mathematically, numerically at income levels, future income levels, good faith criteria, and we're filling out paperwork. And what that really does is it lets us get on the same page with how the Department of Education is going to see these cases. So we can actually evaluate and predict, is this going to be a good case that's worth pursuing? So that's the first part of it. But again, coming back to enforcement, if the Department of Education agrees, and again, it's math and numbers and a spreadsheet. If they agree with our numbers and we've got to prove all the numbers, we've got to submit all the documents, then they're just going to settle the case. They're going to settle the case before we even have to take a deposition. And
oh, goodness. So, and that saves everybody a bunch of money.
Is the other game changer. We've got predictability and we've got early settlement ability. And with those two things combined, now all of a sudden I can look at somebody who's broke and say, okay, this is going to cost some money, but I can predict that this is how it's going to turn out. And here's the process. And here's what I think the result's going to be. And I think we can get there in an inexpensive way.
That is an awesome shift in policy.
And also great game changer, because we're doing this analysis at the very, very beginning of the case. If I'm wrong and the Department of Education doesn't agree, then we can walk away really, really early in the stay. I
was going to say, you still have runway to do something different.
Right.
Yeah.
And maybe for a client that's passionate, they say, okay, then we're taking this thing to trial. But sometimes for a client, they just say, you know what? I haven't invested that much money in this. Yeah. I tried and I'm going to let it go. But because we did this so early in the game, it's not the same level of cost as if we were preparing every case for trial.
Yeah, exactly. So when you look at these, are all student loans kind of game for this, or are there some specific requirements?
All right. So this is a reason why a lot of bankruptcy attorneys aren't taking these cases, because you also have to know student loan law. You got to know bankruptcy law. You have to be able to file an adversary lawsuit against the Department of Education. That's something that not a lot of bankruptcy attorneys do. And then you also need to do some student loan analysis along the way. So, quick answer, private student loans are never going to qualify because they're not held by the Department of Education.
Okay, yeah.
There's also some historic student loans. There's something called the FFEL loans. Those aren't going to qualify either. And so, again, that's part of the analysis. This is what we can predict when we do a consultation. When we get the data, we could say, okay, for most folks, your student loans are held by the Department of Education and they're going to qualify for this. But then we also get into the specifics, and then we look at the loans and we say, ooh, well, maybe only 90% of your loans are going to qualify for this, and 10%
because you've
aren't.
got this private one over there, yeah.
But every once in a while, you have a consultation where you say, I don't think any of your loans are going to qualify. Just don't give me your money, right?
Yeah.
And there's other student loan resources available, but bankruptcy is not going to be the route that I would choose for that person.
So what does the application or the legal process look like when someone has a student loan they're going to seek relief from?
All right. So step one, you have to file bankruptcy. This is only for people in a bankruptcy case. Step two, I recommend you get the discharge. The discharge is the sign of a successful bankruptcy case. And usually your discharge comes 3.5 months after Chapter 7 is filed. We can do this in a Chapter 13 too, but in a Chapter 13, that discharge comes usually at month 60. You get the discharge.
Quite a ways down the road.
Yeah. But still, it's a discharge that we can do. So now that we have the discharge, we file a lawsuit. It's called a student loan adversary proceeding. We call them SLAPP cases, student loan adversary proceeding. It's a lawsuit that we file against the Department of Education inside the bankruptcy case. And the allegation is that the student loans should be subject to the bankruptcy discharge.
And how long does it take them to respond to something like that?
For a while there, it was 3 or 4 months. Okay. Right now, because of unstaffing, layoffs, voluntary, involuntary retirements, the Department of Education is a lot smaller. And so it can be 8 or 12 or 16 months. So it's still the beginning stage of the lawsuit. So we pause the lawsuit at the beginning and we wait for the Department of Education to review the case. So it's not fast.
Yeah.
But for most of that 8 months, there's nothing to do. We prepare all the paperwork, we submit it, and then we just wait for a bureaucrat to review it.
Okay. And in the meantime, are you still getting letters and phone calls? Are you making payments? What's happening on that side?
I usually request that people just enter into a deferment if we think that they are a good candidate.
Okay.
Yeah, complicated.
This has been some really amazing information today. Thank you so much for coming and sharing that with us.
You're welcome. It's complicated, but it's also life-changing.
And it's manageable.
Yeah, but also the reason why it's complicated, both with the taxes and the student loans, is so that you find the right people, right? And that's the difference. Just really quickly to get on a political soapbox. That's the difference between trying to forgive money for every single American, saying every American should get $10,000 off their student loans. Some people love that, some people hate that, but that is broad-based, right? Bankruptcy is targeted. And the reason why we have so much paperwork is it's designed to see, are you, the client, the right fit to discharge this debt in bankruptcy because you can't afford to pay it? And that's what's great about bankruptcy. It's individual, it's case by case, and then you can help the people who really need it.
I love that. Visit convenientbankruptcy.com to learn more or schedule a free consultation. Remember to like, subscribe, and share this episode with someone who needs a fresh start, and we'll see you on the next one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.